about the legalities of the Iraq War, whereas this, as the Attorney-General made clear yesterday, is a political decision, not a legal. No, I'm not going to give way because I have to go. I haven't got time. Sorry. Obviously, yeah. But
thank her for giving way. She's very generous. Can I just point out to her the only point I was making? The comparison was about the risk of cherry-picking, and I don't think anyone would argue that the Iraq War and the position that was set out by Lord Goldsmith actually cherry-picked that advice to maximise the government's position and to press its case.
I do believe that the two issues were conflated, and that this was used as a basis to argue that for the revealing of the legal information now on a wrong predication. I would just like to make that point. I'd also like to go on next to my point about the civil servants and the legal advice that the government receives. You know, Mr. Speaker, I have been in a quandary about this and about this vote today. I would like to see the full legal evidence, as I'm sure everybody in the House would. But there are conventions and also other people to consider, and civil servants fall into that category. They serve us all with true independence, absolute independence. And I don't know where any government ever would be in this place if we could not depend absolutely on the impartiality that we received, of the legal advice that we received from those civil servants. And if this motion is passed today, if this amendment passes today, what civil servant, what legal adviser would ever want to advise any government in the future without first putting in place a filter of self-preservation, of considering that advice that they gave? Who would want to do that as a civil servant? And I think, although I would love to see this legal advice, we have a duty to consider others, the people who serve both the public and us. I actually have 100% respect for civil servants. They work amazingly hard. They are truly independent. They serve us without any political bias, and I think that is something which should absolutely be considered. In terms of the public interest and the points the Attorney-General made yesterday, you know, none of us know if there are any issues, apart from the Attorney-General and the select few, none of us know if there are any issues in that legal advice which pertain to national intelligence, national security, or any other of those issues. And I only have to assume that when the Attorney-General spoke yesterday about public interest, he was talking in the much broader context. And you know, Mr. Speaker, this is an important issue because in the course of law, and I think I'll just quote the Attorney-General yesterday, there is no procedure by which this House can have redactions or entertain circumstances in which it could weigh the competing public interest against the interest of disclosure as a judge would do. Now, given what happened with the publication of the summary of the legal advice during the Iraq War, This inevitability that's happening today should have been foreseen then, because we live in a changing world. We live in a world where people demand transparency, where they have a right to know all the full information. Mr. Speaker, I believe that a resolution should have been passed in this House to give powers to this House, because after all, Parliament is a court, to give powers and a process in this House whereby this House, probably via your office, Mr. Speaker, through the authority of your office, via the clerks, via independent judicial advice, should be able to take a decision and redact matters of national intelligence and security from legal advice so that people in this House can see legal advice. And I hope that as a result of what's happened today, and given that it will happen again in the future, the demands to see legal advice, that the House will now take some cognizance of this and decide to pass a resolution that will ensure that we don't find ourselves in this position again. Also, I'd just like to go on and say, Mr. Speaker, that we have been told the worst as far as I'm concerned. The Attorney-General pulled no punches. When he said there's nothing to see here, actually he told us what needed to be seen. And for me, I'll again quote his words. There is therefore no unilateral right for either party to terminate this agreement. This means that if no superseding agreement can be reached within the implementation period, the protocol would be activated and international law would subsist if negotiations are broken down. He told us the worst. We will be in the backstop in perpetuity. That was as bad as it gets. If we cannot withdraw from the backstop following the decision of this House, we are trapped, as somebody said, from a sedentary position yesterday. And I believe that no MP with any conscience, given with what the Attorney-General told us yesterday, could actually vote for the withdrawal agreement because he pulled no punches. He told us the worst it can actually be. And I commend him for that. And I want to finish, because I have to, with with a comment about us. You know, I listened to the Right Honourable and learned gentleman for Holborn and St Pancras when he said those words at the dispatch box. And one day, and I hope he's white in hair and long in tooth before he gets there, but he may be the Attorney-General. And his words may come back to haunt him at some time in the future. And I could see, I have watched him many times, and I could see that thought going through his eyes. As a legal advisor, formerly, to one of the most eminent law firms in the country, he knows full well, when he stands at that dispatch box, what he is saying and what he is doing. And I hope you never find yourself in the position that you have put our Attorney-General in. And I would like to finish, Mr Speaker, with this.
I can't quite understand why the honourable lady thinks that someone of my limited capabilities aspires to the high office of Attorney-General. Nadine Dorries.
Absolutely, Mr Speaker. Mr Speaker. And I should know better. I should know better. I apologise. I would like to finish with this, that we are all, before we are Attorney-Generals, before we are Mr Speakers, before we are French bench spokesmen, we are all MPs, we are all elected members. And I believe that both the Attorney-General came to this dispatch box yesterday in both honour and in good faith and was honest. And the result of what will happen today, if this amendment is passed, that the integrity and the reputation and the honour of a good man will be traduced. And that will be a disgrace of this House to do that, because any one of us may one day be in that position. And God hope that it does not pass today for that reason.
Mr Nigel Dodds.
Thank you very much indeed, Mr Speaker. And it's a pleasure to follow the honourable lady, the member for Mid Bedfordshire. And I don't agree with the main thrust of what she said, but she did make some very, very useful and pertinent comments about what the Attorney-General said yesterday in terms of the analysis of where we find ourselves. I agree with her and other honourable and right honourable members who have praised the Attorney-General and his candour and his honour and what he has brought to this House yesterday in terms of more truthfulness, if I can say, about what this deal actually means, in contrast to others who have been prepared to say things to the press and media. He came here as a member of the Cabinet and told us some of the unvarnished truth about this agreement. So I do praise him for that and join with the honourable lady in what she has said, because when I went through the adjectives that he used in his devastating commentary yesterday about this deal being a calculated risk, unattractive, unsatisfactory, undesirable, that it did provide no unilateral exit clause for the United Kingdom, it was indefinite, no unilateral right to terminate. But he asked us to take it on trust that it would all never happen because, believe it or not, having spent 18 months negotiating all of this, the EU and the Irish Government don't actually want to implement any of it. The fact is, Mr Speaker, that despite all of the candour and all of what was said yesterday, the coming to this House and making, yes, 2.5 hours of an oral statement and taking all the questions and providing the reasoned position paper does not actually fulfil the order, the motion that was passed by this House, which was for the final and full advice provided by the Attorney-General to the Cabinet to be published. Now, the Government may not like the fact that this was passed by this House, but it cannot simply wish it otherwise. During the course of the debate on the 13th of November, it argued that it would do precisely what it has now done. That was rejected by the House. The House passed a different motion. And it is not good enough now for ministers, and it's not particularly the Attorney-General we single out, because he said himself in a statement yesterday that he wished that he wasn't in the position that he was in. But it is the government as a whole which is collectively responsible for deciding that it will simply ignore this binding effective motion and revert to doing what it said it would do during the debate. Well, quite frankly, Mr. Speaker, that cannot be allowed to stand. We've heard a lot of talk about precedent and about conventions of this House and respect for all of that. Well, surely this is one area where the government must respect the will of Parliament and simply cannot set it aside. The Father of the House, in his intervention earlier, made a very interesting and I think a positive contribution about a way round this. But it's interesting that the government didn't take that up. It didn't take it up during the course of this debate, and it hasn't taken it up previously. So clearly the government isn't interested, it appears, certainly hasn't said anything publicly up to now about taking that suggestion forward. What it has done is say, no, it doesn't matter what is said by this House, doesn't matter what other suggestions are out there, we are going to stick to the plan. They obviously have a grid somewhere where this is on the plan, that they will publish this reasoned summary position paper and have a statement, and that is it. Mr. Speaker, this House will have the final say, and I hope that it will reiterate what it has previously ordered on the 13th of November to be done. Now, we're told that this is unprecedented. There are, of course, it was said in the other place yesterday, that in exceptional circumstances, advice like this can be published. I've also heard the argument used that this is privileged. But, of course, privilege in the lawyer-client relationship belongs to the client, not the lawyer, not the person given the advice. The lawyer has a duty to protect the client's privilege, but the reality is that if the client waives that, then the lawyer, the provider of the advice, is quite at liberty to disclose. So this argument about privilege is a bogus argument. The Attorney-General says that he would wish to come out. The Attorney-General said yesterday, and the Leader of the House, I wish I could comply with the order of the House, but it's not in the national interest, not in the public interest. I'm afraid it's not the duty or the job of any government minister to decide that. The House has decided what it wishes to do, and it's not for a government minister to unilaterally override that with no good reason. I give way to the honourable gentleman.
The right honourable gentleman is very kind to give way. He's a patriot, and I know that he therefore understands national security and the national interest. Would he agree with me, however, that quite probably within the legal advice that the Attorney-General gave to the government would have been an analysis of the strengths and weaknesses of the Irish government's position? And does he agree that to publish that in full would actually hand to the Irish government an advantage in any subsequent negotiation?
I'm tempted to say to the honourable gentleman, I think the massive advantage to the Irish government and other governments and to the European Commission is handed over in this withdrawal agreement in terms of future leverage over the negotiations. But I don't accept what he says, because the Attorney-General went on record yesterday as saying that there was nothing to see. Nothing to see here, so there obviously is nothing of concern about national security in this. That's what he said himself. So I don't accept what he has said. The reality is, Mr. Speaker, that had the government, this debate was had on the 13th of November. That's right. The government had the choice to vote against and decided not to vote against because they feared that they would lose the vote. And it cannot be the case, that by abstaining from a vote on a humble address, that invalidates the motion. because that would be a very, very serious precedent to set indeed. So, Mr. Speaker, we have had the situation where some of this legal advice, as given by the Attorney to the Cabinet, and it's that advice that is crucial that we must have, has already been leaked by members of the Cabinet to the press and media. And the Attorney-General, I think, accepts that.
He shrugs his shoulders.
So the reality is that members of the Cabinet have already released some of this advice given by the Attorney in terms to the Cabinet to members of the press and media. I think that the Attorney is somewhat stopped, if I may use a legal phrase, from saying that the rest of us, therefore, are not entitled to have that. I think if some members of the select media and press are entitled, then I think the members of this House are entitled to have this advice. I'll give way to my honourable friend.
Will you remember agree with me as well that if the government and the Prime Minister is going around the country trying to convince the populace that this is a good deal, that this approach, this secret approach, only confirms in people's minds that there is something to hide. And in fact, if anything, the government is scoring an own goal by refusing to publish this advice.
I thank my right honourable friend, and indeed that very point about the government actually scoring a massive own goal in its own terms has been made not from these benches but by a former Cabinet Minister on their own side and by many honourable members on the government benches. So the right honourable member sums it up for you. What is there to hide, given that the Attorney has said there's nothing to see, given the fact that we have the clear motion passed in terms by this House? It is absolutely vital now that that is enforced and the bogus arguments against it are rejected.
Thank you. Mr. Dominic Grieve.
Well, thank you, Mr. Speaker. Mr. Speaker, I'm not sure that members of the public coming in to watch our debates would necessarily appreciate our role as the High Court of Parliament, but that is what we are. And by virtue of history, we've been given a whole range of powers enjoyed normally only by others of Her Majesty's courts, by which we both regulate our affairs, maintain our own privilege, which also means, by virtue of the Bill of Rights of 1689, that we can't be impugned in any other court, and have coercive powers for dealing with those who transgress in front of us. And that can include government ministers. The difficulty we have, I have to say, from having served on the Standards and Privileges Committee and also been a law officer, is that our powers are entirely archaic, almost completely unusable, and in many cases are so old-fashioned and antiquated that any attempt at using them would probably run foul of most modern principles of justice. And I'm afraid that this situation has been allowed to prevail for decade after decade by a mixture of a failure of the House to grip the problems it faces and, of course, the happy complacence of government that has known that in reality the teeth are not really present for this House to assert its authority. And nowhere do we see this come to a head more than with this issue. It's all very well criticising the Right Honourable Gentleman, the member for Holborn and St Pancras, that the instrument he's used is a blunt one, but there are only blunt instruments to be used. And he was fully entitled to table the motion he did and to seek from the government the documents that he wanted. And the government chose, I have to say slightly to my surprise, Mr Speaker, not even to oppose the motion, even though there were compelling arguments that could be presented, and indeed I can continue to be of that view, that the law officer's advice should not be published because it undermines the ability to provide proper confidential advice to government. That said, Mr Speaker, the method that was adopted, and it may simply have been because of the speed with which the drafting took place, was undoubtedly very blunt. Given its ordinary meaning, the humble address, as I interpret it, extends not just to the Attorney-General's advice, but to every advice that was provided to government during the course of the 2.5 years of tortuous negotiations with the EU, provided through the civil service at any time about the development and impact of the withdrawal agreement. I have no doubt that most of that is general to the Cabinet concerning the terms of any withdrawal agreement. I simply